Hi, my name is Brian Larson. I'm a PhD student in rhetoric and scientific and technical communication at the University of Minnesota. I'm a teacher of Writing Studies 3562, Technical and Professional Writing, and I'm also a lawyer. I prepared this presentation for students in 3562. My goal is to give you an overview of the topics of law that are commonly referred to as intellectual property. These topics include copyrights, trademarks, and patents, as well as some odds and ends. They relate to creative works, product and company brands, and inventions. This video is for educational use only. Please contact me for permission if you wish to use it for other purposes. This first part of the video will cover an overview of intellectual property and part of the topic of copyright. Before viewing this presentation, you should have downloaded and read Circular 1 from the United States Copyright Office. You can find copyright materials from the Copyright Office at www.copyright.gov. Circular 1 is available at these addresses. The first is for English, and the second for Spanish. I'll refer to Circular 1 by page number in this presentation, and where I do so, I'll be referring to the English version. Okay, I mentioned up front that I'm a lawyer, but I do need to make a couple of disclaimers. Let's call them my Miranda warning. First, you should understand that these presentations favor speed over thoroughness, so this is an extremely simplified view of these topics of law. Second, I don't mean anything I say in this video to be legal advice. If you have a real issue in your school or work life relating to these areas of law, you should seek professional guidance. So, you've probably heard the term intellectual property used to refer to copyrights, trademarks, and patents. The term has been around for at least 150 years, but it did not come to be used as an umbrella term for these three topics until after the middle of the 20th century. As it is used now, intellectual property refers to copyrights, trademarks, patents, and some other odds and ends, including things like trade secrets. The use of the word property in this expression does raise concerns for many scholars and commentators. Because of some of these concerns, I try to avoid the use of the term intellectual property in my own speech, but it turns out to be a handy shorthand for referring to its constituent topics. So let's see how many times I end up using it in this presentation in spite of myself. One thing you might want to ask is what these topics have in common. As it happens, they don't have much in common other than their commercial roots. However, historically and theoretically, they do arise from a sort of common principle, and that is that the government grants a monopoly to someone in return for achieving some theoretical public good. So let's talk about that exchange of a monopoly for some kind of public benefit that you provide. How does that work in the case of each of these types of law? In the case of copyright, in theory at least, the government offers you a monopoly on copying and distributing something that you write, let's say a story or a song, as a means of encouraging you to write it. The theory goes that if you know you will be able to control the commercialization of what you write for a period of time, you will have an incentive to write and commercialize what you create. Turning next to trade and service marks, here traditionally businesses and the government were worried about mislabeling. If a consumer is purchasing a pair of Nike shoes, she probably wants them to come from Nike, the company founded in Oregon in the United States of America in the 1960s, and from no one else. If the government grants you a monopoly, or an exclusive right, to use a particular logo or product name, consumers of products like yours can be more confident that you are the source of any product that has your logo on it. Finally, patents, like copyrights, are intended to encourage creation. In this case, inventions. In return for an inventor disclosing her invention to the whole world through the United States Patent Office, she gets the exclusive right to use it for a period of time. We'll spend the least time on patents in this presentation because it's the least important of these three fields to the field of technical communication. So let's stop here for a review. In a moment, I'll ask you to stop playback of this video and see if you can answer the following questions. This is a good time to jot down some notes if you are making them for your own use or to make a forum post in our online class. Okay, stop the video now and consider your answers to these questions. Start it again when you're ready to proceed. So let's start with an overview of copyright. We'll spend more time on copyrights than on the other topics in this presentation, as copyrights are probably what matters most to technical communicators. As we talk about copyrights, we'll discuss the sources of law and what works are covered by copyright. In part 2 of the videos, we'll discuss what the author's rights are, then we'll spend some time on copyright infringement and fair use. Well, let's get started with sources of law. As it happens, the sources of copyright law are quite ancient. They're not actually that ancient, however. In fact, the first copyright statute in the English-speaking world was the Statute of Anne in Great Britain in 1709. The long title of the statute is An Act for the Encouragement of Learning by Vesting the Copies of Printed Books in the Authors or Purchasers of Such Copies during the times therein mentioned. But I'd like you to remember that date, 1709, as we'll consider it again in a moment. There's also reference to copyright in the United States Constitution, which was drafted in 1787. Article 1, Section 8, Clause 8 addresses both copyrights and patents. Here's what it says. Congress shall have the power to promote the progress of science and the useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. As a consequence of the authority given Congress by the Constitution, there have been copyright statutes in the United States since 1790. There were major revisions in 1909 and 1976. The current copyright law is called the Copyright Act of 1976 because that's the last date of a major overhaul of copyright law. But there have been many revisions since 1976. If you are looking for copyright law in the United States statutes, you'll find it at the beginning of Title 17 of the United States Code. So one question that we should ask in the context of copyright, and it relates to what we've already discussed to a certain extent, and that is this theoretical benefit to society of the copyright monopoly. So remember, we said earlier that the public benefit for copyright is that it encourages creative works. By giving authors exclusive rights to their works during some period of time, we encourage them to produce them because they'll want to commercialize what they produce. So that's the theoretical benefit to society. The question is this necessary? How do we know whether this is necessary and how valuable it is? So we know that the theory is there behind this idea because the Statute of Anne, for instance, is called an act for the encouragement of learning. And the belief of Parliament at that time was that they were encouraging learning. And the language of the Constitution talks about promoting the progress of science and the useful arts. So this exchange appears to be at the root of copyright law. But is the copy monopoly necessary to promote creative production? Think back to the date of the Statute of Anne. Do you remember when it was passed? Well, it was 1709. Now, I'm wondering if you can think of any folks who are writing creative works before that. I have a couple in mind. So the ones I was thinking of were Shakespeare, who wrote at the end of the 16th and beginning of the 17th centuries, and Milton. The fact that those folks wrote these important works before there was a copyright law proves that it isn't necessary to have a copyright law in order to have creative works. But maybe copyright greatly encourages the production of creative works. There are a lot more works being written now than there were in the time of Shakespeare, although there are maybe a lot of reasons why that's true. So if copyright encourages the production of written works or creative works, then we might consider it very valuable. Unfortunately, we don't really know how valuable it is. Economists and scholars have tried to calculate the cost to society of granting the monopoly, because it prevents the free use of new creative works, and balance it against the estimated increase in creative works for which copyrights are an incentive. And they can't agree on the results. So, for our purposes, you should just know that the subject is controversial. Let's move on and consider what works are covered by copyright. So copyright covers a variety of works, and these are described in Circular 1 from the Copyright Office on page 3. The definition is original works of authorship fixed in a tangible medium of expression. And this includes a wide variety of items. So let's look at some examples. For example, literary works. including things like books, and also creative sequences of text and numbers like computer programs are protected by copyright. Musical works, dramatic works, and choreography are all protected by copyright. Pictorial, graphic, and sculptural works are protected by copyright. Motion pictures and audiovisual works are protected. Sound recordings are protected. And even architectural works are protected. So the definition of copyright protected works breaks down into 4 elements. Let's take them one by one. First, to be protected by copyright, a work must be original. What does that mean? Well, it can be a tough question sometimes, but in one case, the U.S. Supreme Court said it requires some spark of creativity. That's probably just begging the question because we still have to figure out how bright a spark of creativity is required. In that particular case, which is called Feist Publications versus Rural Telephone Service, the court said that the white pages of a telephone book are not creative enough to have copyright protection. The white pages are just a printout in alphabetical order of the name and phone number of everyone with a phone number. Hardly anyone uses them anymore anyway. In terms of assessing whether something is a work of authorship, we've already talked about that as one of the categories on the previous slides. If we're talking about whether something is fixed, we're interested in whether it's recorded in some fashion. According to the Copyright Office, the fixation need not be directly perceptible so long as it may be communicated with the aid of a machine or device. This includes images, documents, and music recorded digitally. And finally, a tangible medium is really any means of recording other than the human memory. It includes jottings on paper, things carved in stone, and items recorded in a computer's memory, on a CD, on a hard drive, etc. So, having discussed that, let's think about whether this example is copyright protected. We have a jazz musician who's giving a live performance of an improvised musical composition. The question is this performance copyright protected? The answer is no, and the reason it's not is that it's not fixed. If a song or improvised musical composition is not recorded or written down somewhere, it's not protected. Extemporaneous speech that's not written down by the author or recorded at her direction is also not protected by copyright. You might also want to know what other things copyright does not protect. Well, there's a wide variety of them. First of all, copyright does not protect ideas. Things like mathematical formulas cannot be protected by copyright. Sometimes, though, an idea about how to do something, a process or a method, can be protected by patent law as an invention. Facts, like names and telephone numbers, are not protected. But if they're selected, coordinated, and arranged in a creative way, they may be subject to what some folks call thin copyright as protected as compilations. So, for example, we mentioned before that the white pages of the telephone are not protected by copyright. But a telephone directory of ethnic businesses in New York City was considered to be copyright protected by a court because its author had selected the businesses to include. The yellow pages, because they're full of art, are generally protected by copyright. Titles, names, and short phrases and slogans are not protected by copyright, but if they're used for a product or service, they may be protected as trademarks. And finally, U.S. government works are not protected by copyright, but note that this refers only to works actually created by the U.S. government. Works created by states, counties, etc. are still covered by copyright, and you should not assume that something is not subject to copyright just because you find it on a U.S. government website. It may have been created by someone else and posted on the government website with permission. So let's do a review. In a moment, I'll ask you to stop playback of the video and see if you can answer the following questions. This is a good time to jot down notes if you're taking them for your own use or to make a forum post in our online class. Stop the video now and consider your answers to these questions. Start it again when you're ready to proceed. That's the end of part 1 of this video series. Please tune in to part 2 to learn more about copyrights and trademarks. Thanks.